if you could start by sharing with me your place and date of birth and where you grew up, that would be great.
I grew up in Norwalk, Connecticut, born and raised, and graduated from Norwalk High School in 1962. Norwalk, Connecticut is in southern Connecticut, kind of a neighbor, indeed on the border with New York. And Norwalk, Connecticut, by car or also by train, is about an hour away from Manhattan.
Great. And so you were born and reared there, is that correct?
Yes.
Okay. And can you tell me a little bit about your family, your parents or family members, and what life was like during your growing up there?
My mother and father was somewhat like what was called the Black Exodus from the South towards the North, the Midwest, and other places. However, their migration from the South in Atlanta, Georgia, in the neighboring surrounding area where they were raised in the 1930s was not due to any escape from Jim Crow segregation. Rather, in a very unusual kind of relationship, my father was the butler, the chauffeur, the captain of the yacht, and the pilot for a small Piper Cub plane. And my mother was the maid and the chef and the nanny for Candler Dobbs, who was the president and chief executive officer and chairman of the board of the Coca-Cola Bottling Company. And in the 1930s, the Coca-Cola Bottling Company decided to send its executive staff to New York City in order to join the New York Stock Exchange. My mother and father lived and served the Dobbs in Manhattan for a couple of years, but they didn't like the city life. So they moved to a tawny upscale town in Fairfield County in a place called Westport, Connecticut, and even further into a select part of the neighborhood, a place called Saugatuck. And they bought a mansion which sat on the shores of what is called the Long Island body of water. And my sister was born around 1936. She's 8 years older than I. I was born in 1944. I have some vague memories. We lived over about a 4 or 5 car garage, again, on the Long Island Sound. And I've seen pictures where Dobbs, the CEO, had about 5 or 6 cars. One was the limousine, one was the standard car, and then about 3 of them were antiques, going back to the 30s and below. And he also had a boat and a yacht, and my father was the captain. I can remember once when the yacht was moored in New York City and Manhattan, that we took a long trip down several cities of the Atlantic coastline. My father would sail the boat, though, from New York to Miami, and then take it over to Cuba in those early days. And we moved from the estate around 1950, when I was 5 or 6 years old, to Norwalk, Connecticut. Dobbs lost all his fame and fortune and family due to alcoholism. We moved to Norwalk, Connecticut, and somewhat viewing this experience from a white person's lens, the Dobbs were kind enough to select a home for my parents and to give them a down payment on the home. And through this white lens, they selected a white working class neighborhood. I went to the first grade in Norwalk, Connecticut, at a elementary school called Winnepaug, named after Native American Indians, of course. But I was the only black student in this all-white elementary school from grade 1 through grade 6 in promotion to junior high school.
That's a fascinating story.
Yes, it is.
Do you think that experience shaped some of your work, some of your future desire for work?
I'm not sure of that question, but I'll tell you one other little story. For these 6 years that I was in elementary school, we had a little rat pack, like Dean Martin and Sammy Davis Jr., of 4 boys. One was a newly arrived immigrant from Israel named Peter Schoen, Jewish. The other was an Italian ancestry named Malkin, Peter Malkin. And the third was an Englishman named Hemingway. And we were one for all and all for one. But if any of the children called us the K word for Jews, or the N word for blacks, or the G word for Italians, or the L word for English, the fight was on. And I grew up with all of them, and I've remained close to the family of Peter Schoen, the Jewish member of our group.
That's great. Thank you. Well, are there people in your early life or events in your early life that influenced you to pursue a career in law? What led to your pursuing?
When I graduated from Norwalk High School, and later you could pan over to that photo on the wall where you will see the hockey team of Norwalk High School in 1962. And I was the captain and high scorer of the hockey team. We played all over New England and New York. It was often said that I was the only black hockey player, certainly in all of New England and New York, and they used to say, as far west as they could see to North Dakota.
That's great.
And when I graduated, I was destined to go to a small New England, upstate New York liberal arts college and play hockey. However, my sister was 8 years older, and she had gone a year to Spelman and graduated from Howard University, and she told my parents, no, he's not going to go to any predominantly white school and play hockey. He's going to go to a historically black university and learn how to live with the people who look like him. And so that took me to Howard University in 1962. And from 1962 to 66, when I graduated from Howard University, I hung around with the likes of John Lewis, who had just stepped down as the head of SNCC, Student Nonviolent Coordinating Committee, an activist organization during the Civil Rights era, and Marion Barry, who was the head of SNCC for Washington, D.C., went on to become the mayor for life, quote unquote, of Washington, D.C., and H. Rap Brown was always in town, burn baby burn, quote unquote, and many other activists. Indeed, I once was a part of a student group that escorted Muhammad Ali on campus. And Muhammad Ali said in his famous colorful use of words, both in the actual color and in the actual metaphor, that no black man should fight a war started by a white man to kill yellow people who had done nothing to the black man. And if the black man was going to fight anybody, he should fight the people who lynched him. And he paused and let everybody figure out who that would be that they would fight and kill. So by the time I graduated from undergraduate school, I was active in the civil rights movement and active in the anti-war movement. Indeed, I received a deferment, like I say, quote, all my white buddies did. They went to college to avoid the draft. And we were like Bill Clinton. And we were like other top elected officials who did not serve in the Vietnam War, including Donald Trump and Dick Cheney. And so that's what led me towards going to Mississippi in a very novel, indeed cockamamie way. By the time I graduated from Howard University in 1966, I was virtually practicing law without a license. I joined with the Quakers and other peace organizations such as the American Friends Committee and taught young black registrants how to avoid the draft, like Muhammad Ali. And I found out that the draft was like the Internal Revenue Service Code. There were all these rules and regulations. And I became a master of the rules of the Selective Service System. And the draft was the 900-pound cloud hanging over all young men, subject to what was called mandatory conscription. The head of the agency at the time was named General Hershey. So I cooked up a scheme to try and avoid the draft and avoid fleeing to Canada as a refugee. And I went to my South Norwalk, Connecticut, all-white draft board and made up a request for what is called a deferment. I had secured a position at the North Mississippi Rural Legal Services Program in Oxford, Mississippi. I then took that letter of appointment as a young lawyer in this relatively new program called the Reginald Heber Smith Lawyers Program. This was a part of Neighborhood Legal Services. And Neighborhood Legal Services was a part of President Lyndon Baines Johnson's War on Poverty. And I asked my draft board for what is called a 2A deferment. The 2A deferment is what the Selective Service System gave to teachers and firefighters and police officers in what the regulation called the nation's health, safety, and interests. And I asked him if I could go to Mississippi in the nation's health services and health, safety, and interests to be a civil rights lawyer to help the black people get their civil rights. And I'm still surprised today, over 50 years later, that my draft board granted my deferment. And off I went to Mississippi as a civil rights lawyer instead of off to Vietnam to fight a war.
And just making sure we're still recording. What year was that you?
This was 1969. I'm celebrating my 50th year of graduation from law school and 50th year in the legal profession, and from the date that I first set foot, indeed, in this month of July in Oxford, Mississippi.
Wow, congratulations. And so tell me a little bit more about your formal legal training and how that worked and how you got the entree into North Mississippi Rural Legal Services.
I went to Howard University to avoid the war in 1966. The nation thought that President Lyndon Baines Johnson, Secretary of Defense Robert McNamara, couldn't keep up the war much longer. So I really just checked into law school for a year to keep my deferment, and hopefully the war would end. But it didn't. Howard University was stocked full of professors who had been in the civil rights movement. Indeed, my mentor, named Herbert O. Reed, had been one of the original lawyers in the quintet of Brown versus Board of Education cases. Many people think of Brown as the case from Topeka, Kansas, but the Brown decision was a part of 5 consolidated cases, one from South Carolina, the other from Virginia, one from Washington, D.C., and the 4th from Delaware. And my professors, including the president of the university at the time, James Nabrit, were several of the team of lead lawyers in the Brown versus Board of Education. So I learned as much as about the standard law as I learned about civil rights in the law. And that's what set me on the path to eventually become a civil rights lawyer.
And how did you find out about North Mississippi Rural Legal Services?
I found out coincidentally when the late executive director who hired me came to Washington, D.C. into Howard University to recruit lawyers for the Civil Rights Legal Organization. I had begun my planning to, quote, evade the draft. And part of that planning was to go to Mississippi or another southern state so I could ask my draft board to help give the black people in the emerging out of segregation South a chance for their civil rights. And fortuitously, Michael's offer fit right into my plan to ask for a deferment.
And can you tell me his full name?
His name is Michael Trister. He died this past year. I've spoken several times about his legacy and its connection to me.
Can you share a little bit more about him and working with him?
Yes, Michael Trister was himself a public figure and a warrior for civil rights. In the mid-1960s, the University of Mississippi, where just 7 years before I arrived, had gone through desegregation of the all-white university with the admission of James Meredith. Meredith's admission required legal action from the courts up and down. His lead lawyer was Constance Baker Motley, a lawyer for the NAACP Legal Defense Fund, and from Connecticut, who would become one of my mentors. She eventually became the first African-American Chief Judge of the United States District Court in Manhattan. And so Meredith had set the tone for the integration of higher education in the South the way that Linda Brown had set it for K through 12 integration. During the mid-1960s, the University of Mississippi decided to do something about the segregation at the university 7 years again after Meredith integrated. And they appointed a new dean named Joshua Morse. And Morse went off to Yale University and hired a group of young whippersnapper professors to come down there and to raise the profile of the University of Mississippi School of Law. Mike Trister was one of them. And they formed a neighborhood legal services program under the National Legal Services Agency, and they started in Oxford with a program to serve the poor. They were so successful in bringing suits and other public policy advocacy against both state, local, and federal agencies, as well as private businesses, that the system, quote unquote, of the ruling class in Mississippi decided to shut it down and decided to put pressure on the University of Mississippi to stop what is now considered a clinic in modern law school administration. Michael Trister refused, and the university fired him, and he brought suit against the university. And one of his colleagues was joined with him, and they won, both in the district court, and they had to appeal it to the Fifth Circuit Court of Appeals. And they settled, they paid him money. He left the University of Mississippi, and he continued, and he built what is now the modern-day Neighborhood Legal Services Program at North Mississippi.
So when you came on board, it was already separate from the university?
Yes.
Okay. And so what was the early atmosphere when you arrived? What were the kinds of things that they were working on, and what was it like to enter Mississippi at that time?
I did one thing smart, and I did one thing stupid. When I first arrived with my new bride, after we got married in 1969. The first thing I did stupid is that when I graduated from law school, I bought a brand new 1969 MGB British sports car. British Racing Green, convertible with wire wheels, and a souped up muffler system in which you heard the car before you saw it. And when it downshift, it blah, 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 blah. And I also stupidly had Connecticut plates on it. So I was marked from the beginning. The second thing I did is that I met with the local menses, a plural on a plural, as they would say, the local black menses of the area. And I quickly found that while the civil rights movement, led by Dr. Martin Luther King, are based upon the strategies of Mahatma Gandhi from India, of nonviolence, the menses were armed for self-defense. And so the smartest thing I did is I acquired a .38 revolver, long barrel. That's like Wyatt Earp in the old Western movies, about 8 inches long. And I carried it in my briefcase at all times, in federal court, in state court, in the office, and in my MGB. Plus I had a 30-06. The significance of a 30-06 is that it's a very powerful rifle, and it's very accurate. And that's what Delray, or DeLauder, the man who assassinated Medgar Evers in Jackson, Mississippi, used to kill him at about 50, 60 meters away while he was getting out of his car in his carport. And I had a 20 gauge double barrel shotgun and a BB gun for target practice. That was the beginning of my life in Oxford, Mississippi. I was never threatened per se, but I believe it was what we used to say with the old Russians, détente. They know I was armed.
And when you say they, could you elaborate?
I used to call them the SEGs. They still flew the Confederate flag. They still hurled the N-word around, and they acted with a bigoted style. I'll give you one particular instance. In quick succession, in 1969, in my first 6 months, I brought the first school desegregation case against the segregated Oxford and Lafayette County public school system. And we won. And they enjoined desegregation, and the federal court ordered integration. Within that same year, a group of Ole Miss, as they say, black students, went on the stage during the visit of a worldwide peaceful singing organization promoting tolerance, and protested the racist conditions still there, again, several years after James Meredith integrated Ole Miss. And the university and the local police arrested all blacks that they could find, regardless of whether they were there or not, and sent them to the Harchman prison, which would later be declared unconstitutional, because it was the only prison in the country that maintained what is called a trustee system. And under the trustee system, fellow inmates were armed with long barrel rifles and permission to shoot other prisoners and kill them for the so-called maintenance of security of the prison. And I got all of those students bailed out of jail, and they were charged with a misdemeanor offense in the local city courts. And I blocked and clogged the whole city court by requesting a jury trial. And afterwards, we agreed to a settlement in which they would drop all of the criminal charges in the municipal court if we would agree to transfer the case to university due process disciplinary actions. And we agreed to a certain number who would face disciplinary. And I requested a due process hearing for all of those students too, and tied up the university system. And then thirdly, I appeared in a local court on a juvenile delinquency matter under the rules in which I had been licensed to practice in the federal courts of Mississippi, based upon being a licensed lawyer in good standing from Connecticut, my home state, and working for a local nonprofit civil rights poverty legal organization, and not charging any fee. I could appear in local cases with what they call a permission from the court, pro hoc vice, in which you request to appear in just that case, and accompanied by a local Mississippi lawyer. All of that was satisfied in this juvenile delinquency case in which our client was charged with making obscene phone calls. And in those days, if a victim of an obscene phone call called the telephone company, the security for the phone company, in those days the Bell telephone company called Mount Bell, would direct the victim to immediately call after they received an obscene call. And it would trigger what is called this pin register system, where in the olden days with IBM orange cards, the callback by the victim to a certain number would create an electronic card with the telephone number that preceded the call from the perpetrator. And they traced that number to a local family in Oxford with small children. And they investigated and determined that this little black boy probably made the phone call, and they charged him with a delinquency, a violation. And our research showed that there was a party line, and our investigator found that there was another white family on the same party line. Now, when I tell this story today, people never experienced a party line. And a party line is that you had no dialer. You just picked up the phone, and you knew who the operators were, and they were all women. You would say, Mabel, Alice, give me 9467. And she'd pull a wire out and put another plug in, and you get the call. And if you picked up the phone, and the co-party on the phone was there, you would say, how long are you going to be? You've been on for 30 minutes. I'd like to make a call. And often there was politeness. And so the climax was when the prosecution called the chief investigator from Jackson, Mississippi, to testify that they traced this call to this number, and the police investigated and found that the child was home that day. And the punchline question, after setting up the expert, was, quote, did you know that this was a party line with another family on the line? And I don't know how they missed it, but he said no. And I established there was another party line, and the case was dismissed. So here's how we come back to my stupidity with my MG. In those days, a local lawyer could sign a bond to release their client from custody in the jail. And one Saturday morning, the sheriff called me and said that a person who had been arrested and whom I had represented in a civil action wanted me to represent him in the criminal action and wanted me to sign what is called the appearance bond for him to release. And if I came out to meet the sheriff out in what is called Lafayette County, he would release him. Well, in Mississippi in those days, and still to an extent now, they had paved roads and then they had dirt roads. Well, they really weren't dirt roads. They often had gravel on them, so they were really gravel roads. So off I went one Saturday after I polished up my MGB and after I dropped the canvas top for convertible. And I got out on those gravel roads, and I thought I was in the European relay races, Monte Carlo. And I was just sliding around the corners, and I was downshifting and upshifting, and I came up over a hill and came down. There was the sheriff sitting over on the side, and I started downshifting, and turned into where the sheriff was, and the back wheels were just spinning around, and it stopped, and it created this great plume of dust. And I got out, and I walked over to the sheriff. And the first thing he said after spitting, had a big old 10-gallon hat on with a dark stain sweatband around it. He couldn't look over his big tummy and see the tips of his boots. He had his revolver hanging down the side, his sheriff badge on. He said, "Lord Brittain, don't suppose I never seen no sports car like that in Mississippi." And he said, "I never seen a Negro riding in one." Of course, I had to quickly correct him that I'm no black in person, but I am an African-American black man, and don't you ever forget it, and you better never call me that N-word again. He spit over there like he was being a compliment, and he said, and this related to the car, "You better watch out, because that car has marked you." So we conducted the business, signed the peace bond, and sent me back towards the jail. And on my way out, I gunned it up a little bit, stuck it in first gear, popped that clutch, and the wheel just spun out, and the car just zigzagged. Gravel was flying on up, and I left some dust to inhale. Well, soon after that, they arrested me and charged me with a felony of practicing law without a license from that juvenile delinquency case. And that was by the spring of 1970, about a year after I'd been in Oxford as a young lawyer. Michael Trister, the director of the legal service program, Ken Spriggs, another guiding principal in my young career, represented me, and they brought one of the last federal court actions in which you could go to federal court and you could stop a criminal prosecution in the state court if you could show that the criminal prosecution in the state court was instigated on bad faith and malice. And that's what we convinced the judge, coincidentally the same federal judge that had presided over that school desegregation case in Mississippi. His name was William Keedy. And that stopped the state prosecution against me for the felony offense that could have resulted in many years in prison and disbarment as a practicing lawyer.
Were you fearful at that time that they might get away with it?
Yes. It was a cloud over my head for the next year. Some urged me to leave the state. Others said I had to stay and show them that they couldn't scare us and run us out, as us would be the legal services lawyers. And so I stayed, and we had blocked the case. And a year later, I took the Mississippi bar, and I passed it. Now, when I passed it, they immediately admitted me, although no one would be admitted to any state bar, both then and today, if they had an outstanding felony offense of a pending trial with charges for A, practicing law without a license, and B, not having any resolution of the character and fitness issue. Yet they admitted me. And so I called them one day and said, if you drop the criminal case, I'll drop my civil case with damages against you. And so they entered a pleading to drop the and dismiss the criminal case.
Drop the case.
Yes. The cases were mutually dismissed without any paperwork, without any written agreement, just the old gentleman's satisfaction that the Attorney General said and the prosecuting authority, they would dismiss the criminal charges, and when they did, I, through my lawyers, filed a motion to dismiss the civil action. and we let bygones be bygones.
And so how long were you at North Mississippi?
I stayed in Mississippi for 4 years, from 1969 to 1973. However, I left legal services after 2 years, and I went to Jackson, Mississippi, and became a trial attorney with the with the Lawyers Committee for Civil Rights Under Law, Jackson Litigation Office. The Lawyers Committee was started earlier, around 1963, by former President John F. Kennedy. Kennedy summoned 100, what he thought were the best lawyers from around the country. That best is a doubtful kind of description. Nevertheless, they were, though, some of the most powerful lawyers managing large law firms. And Kennedy asked, quote, "Where are the lawyers?" unquote, meaning where are the powerful big law firms in those days providing volunteer or pro bono lawyers to take civil rights cases in the South. And he held those lawyers at the White House over several days in what I teach in my torts class. That would be false arrest. And he waited until they came up with an organization. And that created the Lawyers Committee, and I went to work with them about 7 years after they started in the Jackson office. It would be known as false imprisonment technically in the civil torts action.
So tell me a little bit more about your tenure at North Mississippi Rural Legal Services and in your time there.
One of the best experiences I had, in one sense, is that when fall came, school was back in session. I worked 5 days a week and a half day on Saturday mornings. One day I went in my office, which, by the way, was located in the square. And for people who didn't live in particularly parts of Mississippi in the South, many towns have squares. Up north, we call it a rotary. In other parts of the country, they call it a roundabout. And so the four main arteries came into the city, north, south, east, west. And you came into a circle, and the street circled around. And in the middle was the county courthouse and the county offices. And around it were shops and stores. And it was halfway around what I call a double-decker type of small southern town, somewhat like New Orleans, with a second floor, and some actually had balconies. This was common in a number of small Mississippi communities. And our office was on the second floor of what they call the circle. And one day, Saturday, I went to work. I came out around 10:30 or 11 to leave, and I got caught in the huge caravan of cars coming in from somewhat like Tennessee for Saturday football in the South at Ole Miss. And of course, the Confederate battle flag was flying everywhere. And they just kept coming and coming and coming like a military platoon. And I couldn't even move my car. And I had to listen. And I damn sure had to get out of there by evening, because Lafayette County in Oxford was dry as to liquor and beer. But you could get beer right up the town at the border between Lafayette County and the next county. And so there was plenty of beer flowing by the evening in Oxford, Mississippi. You could have alcohol, though, at a restaurant that served food. And I learned the whole reverence of the Confederacy at Ole Miss in those days, with not only the battle flag, but the big pageantry in the fall, in which they elected what I call Mr. Johnny Reb and Miss Ann. And through representing students And half the time I was on campus because we used the Ole Miss Law School library for any library research that wasn't in our office. There was no electronic research in those days the way there is now.
And so, tell me a little bit more about some of the cases, particularly the desegregation case of the Oxford and Lafayette County schools. Could you tell me about the plaintiffs and how that went and what the atmosphere was like?
In those days, the legal services program had a social action person, a non-lawyer, and he was a community organizer. Later, legal services and the war on poverty with community action programs and centers would abandon that strategy because they thought it stirred up too much trouble, quote unquote. But in any event, I worked closely with our community organizer, and he introduced me to all of the activists in little old Oxford with its segregated schools. And one of the activists was named Mildred Quarles, and she was like the Fannie Lou Hamer, whom I also represented, a noted civil rights heroine. And we became close. I went to her house and ate dinner with her family. She came to our house, and she, like Kennedy said, well, what are the lawyers going to do about segregation? She said, what are we going to do about these segregated schools that were, of course, unequal and on the other side of the track? And that's what led to the first school desegregation suit in Oxford called Quarles versus the Oxford Municipal School District, and Quarles and others versus the Lafayette County School System, more commonly known as the separate school district. Not separate because it's separate and unequal segregation, but separate from the city. They had both the city and the county school districts. And in my travels, it seemed like half of the handful, which is only about 5 or 6, so 4 or 3, of the law students worked as part-time in the North Mississippi Rules Legal Services Office. So that brought me in touch with the other handful of black students at Ole Miss. And we often socialized together, and they became part of our life and our culture. So when they were arrested in this incident of a demonstration, they turned to North Mississippi Legal Services and to me to represent them. Meanwhile, I represented many other communities. For an example, I was hired by the city of Mound Bayou, the first black incorporated municipality in Mississippi and virtually in the nation. Another one in North Carolina competes for who was first to have a complete all-black municipally incorporated city or town. And I represented all the civil rights activism throughout the Delta. I brought the first school desegregation case in Greenville, Mississippi. I represented Dr. Aaron Henry, a pharmacist from Clarksdale, Mississippi, who was the state coordinator for the NAACP, like Medgar Evers was. Of course, I represented Fannie Lou Hamer, who largely headed up the integrated faction of the state Democratic Party, and who gained her name and her claim to fame by appearing at the Democratic National Convention in Atlantic City around 1966 to demand that the Democrats not seat the segregated all-white Democratic Party, but to recognize the newly formed integrated biracial Democratic Party. They lost then, but their loss gained a win by the next time in 1968. And I went on to represent the biracial Democratic Party, who was recognized by the National Democratic Party after 1968 and around 1970 or 71, when we sued the what we call white segregated Democratic Party under state law to be recognized because the state segregated party refused to give up control. And we won that suit, saying that the statute, although it regulated the Democratic Party, was like the Republicans, depending upon who the National Party recognized. I went on to represent others throughout the state in my transition from North Mississippi Rural Legal Services in 1971 when I joined the Lawyers Committee. But going back to the 2 years I was with North Mississippi Rural Legal Services, I represented organizations throughout the area. We had offices in Greenwood, and we had offices in West Point.
And about how big was the staff at that time? Do you remember?
The staff in Oxford consisted of Mike Trister, the director, Kent Spriggs, the deputy director, and about 4 of us who were staff attorneys.
And who were the other staff attorneys? Do you remember at the time?
I don't remember their names now offhand.
And who was the community liaison that you mentioned earlier that introduced you to Ms. Quarles? Do you remember his name?
No, I don't remember his name, but I'll send that to you.
Okay. And so when you represented Dr. Henry and Ms. Hamer, was that at NMRLS or was that when you had transitioned to?
Both.
Okay.
Yes, so I spread out from Oxford in Lafayette County, and we were one North Mississippi Rural Legal Services with offices in several places in the Delta. So I figured that gave me the geographic range to represent individuals and organizations beyond Oxford and Lafayette County.
And what were the specifics of those cases?
I represented employees in the first wave of employment discrimination cases. Of course, I represented parents and children in school desegregation cases. I represented voters in voter election cases, and particularly the first wave of enforcing the 1965 Voting Rights Act. And I represented persons in criminal cases in which legal services could then take criminal cases and defend persons of accused. And I represented persons throughout the civil rights movement in boycotts and in demonstration cases. And I represented homeowners and renters in fair housing cases. So when I teach civil rights today, in what I call my Big 7, but it was originally 6, and you can see why the 7th were added, and they are, without any preferences, education and voting and housing and employment, and the 5th is criminal justice, and the 6th is self-help protests. I represented clients in all those big 6 cases, and this was before my 7th and my teaching and my scholarship, which is marriage equality. So I represented clients in all those big 6 areas.
And can you reflect on specifics of like Dr. Henry's case or Ms. Hamer's case that you represented?
I'll tell you a story about Ms. Hamer's and the cases I would represent. In some of my early cases, I would go to a meeting, often in a church, often in the evening, to talk to people who wanted to take action, to fight segregation. And we would pass around a yellow pad in which we wrote out that I hereby retain John Brittain and others associated with him in North Mississippi Rural Legal Services to achieve our rights in a certain area. And they would sign with their name and addresses. I would take their names and addresses. My investigator would check and confirm, and we would put them on a pleading, and we would file suit. And when we went to court on the first kind of hearing, I would often call upon them as witnesses to testify about the conditions. And one of the standard cross-examinations, but I would call, and I always use this term, the white seg lawyers. They would ask the black witness by starting off by calling her or him by the first name. And I would object because that's demeaning, and that's discourteous, and that's racist. And I would cite a Supreme Court case that found that it was a violation of the rules of court. And I would cite it, and it would cause some groans and some bickering, and begrudgingly the judge would enforce it. And of course it would make the opposing counsel mad, and that was one of my goals, to always pull their chain and make them mad. And I was equally as discourteous to them during the course of these hearings. And they would launch into a cross-examination, say, Ms. Jones, you live up there on the Smith Plantation, don't you? And your husband works for them, don't you? And you don't have any other jobs, do you? And if the Smith Foundation fired you, you would have no place to go, no place to live, and no place to really support your children, do you? No, sir. And you got this lawyer Brittain here to bring your case, didn't you? And you're bringing this case against school segregation, housing segregation, employment segregation. And you don't know what these statutes mean, and you don't know what the 14th Amendment means, don't you? And so you really don't know why you're here today, do you? And you really don't want to be here and risk losing your objection. That's a threat, Your Honor. Sustained. Withdraw the question. All right. But you don't really want to be in this case. And sometimes they would nod and no. And the opposing said counsel would move to drop and dismiss this party from the suit. And so when Ms. Hamer called me, I would tell her this story. We go to court, same routine, come to the punchline. Ms. Jones, Mr. Smith, you don't really know about any of this. You don't really want to be in this case. And once Ms. Jones said, well, I tell you, no, sir, I don't know nothing about these laws. I don't know nothing about this legal case. But I do know one thing. I wants my rights. And that would end that cross-examination. I'd turn around and look at Ms. Hamer. She'd wink at me. I'd wink back at her. I never had any problems after that with any of my black witnesses in black parties staying in a litigation to fight white supremacy.
So going back to the Oxford school desegregation case and Mildred Quarles, how did that, what was the progression of that case, and what was the atmosphere like at that time?
In some sense, Oxford had avoided the brunt of the civil rights movement, the civil rights war, civil rights battles that took place in Mississippi, particularly in the Delta, in Greenwood, where Ms. Hamer was arrested and she was beaten in jail, and in Jackson, and throughout other, quote, war zones in Mississippi, particularly in 1964, when they had the big COFO movement to register voters, and where Schwerner, Goodman, and Cheney were killed in the Delta of Mississippi. Oxford, Mississippi, and mainly North Mississippi avoided a lot of that direct confrontation. And particularly Oxford, because it was a, quote, college town. It was a little bit more moderate compared to those other places. And the Quarles versus the Oxford School District lawsuit in 1969 was the first major battle against segregation in the town. And it created a lot of tension. School desegregation cases in general created tension because white families didn't want their children to go to school with black children. And the case was the tipping point of this new confrontation. So yes, and for an example, I'd often file a suit and go out of town for 2 days with my wife up to Memphis to have some rest and relaxation, and come back after some of the heat and steam had died down, after they learned that there was a lawsuit challenging the segregation practice. And I can recall the first hearing we had in Oxford to establish our case. And blacks often still sat in the colored section of the courthouse, although the 1964 Civil Rights banned segregation in public places such as the courthouse. And I can recall calling black witnesses who established the case, and I can recall calling the white superintendent and white members of the board to establish the segregation. I can recall that the courtroom was packed down there on the square in the old now federal courtroom. And I can recall the second hearings in the early part of 1970, and I can recall the judge, William Keedy, issuing the final order to desegregate the schools, in which the real battle just begun, not the court action, because we had to set up a plan, the plan had to be approved, and then the plan had to be implemented, and the school assignments had to change, and the schools had to change. And I can recall bringing a major case over in West Point, or outside of a place called Nettleton, Mississippi, in which I won that case, and the school district, to implement the integration plan, demoted the black superintendent and the black principals, and some black teachers were fired when the systems were merged. And I had to go back to court a second time in order to get them all reinstated and to divide the leadership between black and white in all sectors of the school system. And so back to Oxford, we agreed up on a plan, and we agreed, often was the case, to take one of the black schools and shut it down and completely renovate it. And they would pave the sidewalks, they'd create nice fences, they would upgrade the playgrounds and the outside play, and they would completely renovate the inside the school, because that's where white children now would attend, along with black children. So in some sense, school integration improved the former black facilities. And of course, white children would go to some of the, quote, white schools for integration.
Were you aware that they just demolished Central High School?
I just heard it recently.
Oxford.
The old black high school.
Yes. It's, raised some emotions, I think.
Yes, because it eliminates that black history.
Yes.
And history is a part of education.
Any more reflections on Miss Quarles herself?
Miss Quarles was steadfast. And we stayed friends and stayed in touch with each other for decades. And she stayed active in Oxford on behalf of the people. Mildred Quarles.
Thank you. So I don't want to...
By the way, Mildred Quarles, Thin Lou Hamer, and others taught me to pick leaders in the community as plaintiffs. They had the grit to fight white racism, white supremacy. They had the staying power to last beyond the suit. And they had the leadership qualities that created support among the community to fight for their rights. I later, in 1990, would bring a big landmark school desegregation case in Connecticut called Sheff versus O'Neill. When I first went to Connecticut, as a little diversion from Oxford, in 1977, to become the first African-American tenure-track professor at my, quote, home state law school, the University of Connecticut. I simply rode around the streets as I had done in Mississippi when school started at 8 in the morning and when school let out around 2:30 or 3 o'clock in the afternoon. And I just followed the students back to their homes, walking by bus, and looked at the racial composition. And that was an instant first check of whether the schools were segregated. When I did that in Oxford, in the cradle of the Yankee land in the north, and saw the schools there were just as segregated in Connecticut as they were in Mississippi towns, I decided to bring the first major school desegregation case in Connecticut. And when I thought about plaintiffs and I thought about Mrs. Hamer, I searched and I almost auditioned potential plaintiffs like Steven Spielberg and Spike Lee do in making a movie. And I picked a person on references from many people who was a community organizer, was a minister, was active in the South African anti-apartheid boycott movement, was the leader of a public housing development, and worked with a public service nonprofit organization. And I picked her as the lead plaintiff. And she had a photogenic child, Milo Chef, who was in elementary school, to be the poster child for the lawsuit. We started that lawsuit in 1989, 1990. This past year, in 2018, suit was decided in 1996. 2006 is 10 years. 2016 is 20 years. And 2019, 20 years, is 23 years. We had the 20th anniversary. And Elizabeth Horton Chef, who went on to become a popular city councilwoman, is still a leader in school integration and school diversity in Connecticut 23 years later. Indeed, 30 years later after we filed the suit.
That's great. So actually that leads me to a good question about Mississippi as a training ground. And one of the arguments that we make in this oral history project is that one of the benefits that North Mississippi Rural Legal Services provided was as a real training ground for young African American lawyers in the state, because it was so hard for them to find jobs in other places at that time. And I wondered if you could either affirm or comment on that notion.
When I went to Mississippi in 1969 in Oxford, I first established relations with the existing black lawyers. When the civil rights leaders planned to select James Meredith, who, by the way, was selected because he was an Army veteran. He was older than most graduates from an undergraduate college. And he stood the test of all that violence, of all that vitriol, and his actual integration, which turned into a riot that required U.S. Marshals and the National Guard. And several people were killed during that initial stage of escorting him. And a governor stood in the doorway until he stood down in the face of all the federal might and enforcement. And I met all of the black lawyers. I knew them because one of them was my classmate at Howard University, and his dad, Jack Young Sr. So when Constance Baker Motley came to Mississippi in the early 1960s, along with Thurgood Marshall, to bring civil rights actions, there were only 4 or 5 black lawyers. And one was Jack Young Sr., another one was R. Jess Brown, another one was Carsey Hall. There was about 4 of them. By the time I got there There were about 6 or 7 of them. 2 of them were my contemporaries. One was Fred Banks, who was a year ahead of me at Howard University. Another one was Reuben Anderson, who was about 2 years ahead of me. But through Fred, I knew Reuben. And of course, Jack Young Jr., I knew him too. Reuben would go on to become the first African American appointed to the Mississippi Supreme Court. Fred Banks, his partner, would become the second. And I became close with all of them. And yes, I looked over the horizon from that original 4 in the early 1960s to when I got there at the end of the decade, and there were about 10 in private practice, and then at least 15 others that had largely been hired by legal services, both in North Mississippi Legal Services and the other legal services programs that grew out of the southern region of the state. That is correct. Legal services provided, 1, access to justice, and 2, the rise of the new black legal bar.
Great, thank you.
Another dimension, though, in this access to justice should be brought out in terms of the organization of Mississippi Legal Services, like the whole Neighborhood Legal Services Program. That was the initial name of it, started by President Lyndon Baines Johnson and Sergeant Shriver with the War on Poverty, with Neighborhood Legal Services. Johnson's new War on Poverty social action program founded Head Start. It also was the beginning of Medicare. And as we celebrated the 50th anniversary of the War on Poverty from 1965 back in 2015, the third major prong of the War on Poverty was Neighborhood Legal Services. Neighborhood Legal Services started as a grant program by the federal government to a nonprofit organization such as the University of Mississippi with North Mississippi Legal Services. By the middle of the 1970s, though, the powers to be, both public and private in states, had created a veto mechanism where the governors could veto these programs in their state, and indeed veto legal services in its funding from Congress. So legal services nationally spun out of a semi-independent federal agency and created a corporation known as the current Legal Services Corporation, LSC, to provide a buffer from the veto power of states. And legal services created nonprofit organizations that were free from intervention by the state. In North Mississippi, particularly after Trister, when the University of Mississippi stopped as a funding agent for North Mississippi, and they created one, a nonprofit, in a little black college in West Point, Mississippi. And that became the nonprofit organization called Mary Holmes College that insulated North Mississippi and allowed the Neighborhood Legal Services Program to receive funds from the Legal Services Corporation. And with a board, it became the new parent organization for North Mississippi Rural Legal Services. I was a part of that transition. And I later would come back, although I went to San Francisco to become a partner in my own law firm, and I continued to represent North Mississippi Legal Services when they got into, quote, trouble, and complaints were brought against them by various sources, and they had to appear before the Legal Services Corporation to defend themselves. I represented them in a number of cases like that. thank goodness for editing
Yes.
in these running videos. I came to North Mississippi Legal Services with the clear intent by Michael Chister, like he came to the University of Mississippi as a recent Yale law graduate to make change. And I came as a part of a relatively new program started by Legal Services about 2 to 3 years. I believe I was in the third or the second year class in 1969, so it started about 1966, 1967, called the Reginald Heber Smith Fellowship Program. And the distinction of the Reginald Heber Smith Fellowship Program, called Reggie's, is that they were hired and they were trained, forgive the analogy, like SEALs or Rangers in the military, to engage in strategic strike action. Legal Services was always known for the very important work of name changes in minor debt actions and small misdemeanors when they could take criminal cases, and domestic, some bankruptcy. And those were called the day-to-day cases. The Reginald Heber Smith Fellows were trained in a 6-week summer program in much more strategic, much more systemic examination of the problems that caused poverty. It was somewhat coming on the post-release of the Kerner Commission report on what caused the disorders, and really one of the seminal reports by the federal government on white racism in America. And so I was brought in to study conditions, and I was thankfully immune from taking daily cases, except to the extent to take enough daily cases to figure out what were some problems, and then to switch into my fellowship role of looking at systemic change. So that's what I did at Legal Services. And Legal Services provided access to justice for people in particularly Oxford and Lafayette County and surrounding counties, that gave poor people, white and black, there were no Latinx in those days, access to justice in courts and in legal representation for legal matters. And hence, Legal Services for the Poor was created by Johnson to provide equal justice for those who could not afford a lawyer, now known by the term civil Gideon. Gideon versus Wainwright was the criminal case that established the Sixth Amendment right to counsel for persons accused of a crime. And over the last 50 plus years, that criminal right to representation has extended into the civil arena in a number of areas, such as child support and other cases, which could lead, by the way, to criminal exposure. But even beyond that, in housing, in landlord matters, in welfare, eligibility, and other administration cases. That, I think, is the landmark, the legacy of North Mississippi Rural Legal Services in providing access to justice for the poor in the county and in the municipality.
Great, thank you. And so there was a shift, and this may post-date your tenure there, where Legal Services Corporation was essentially had the legs kicked out from under them. Was that after you were there?
Yes.
Okay.
When I was there, we could take all types of cases with what I call 2 arms and 2 legs. When the nation celebrated the 50th anniversary of the War in Poverty around 215, I penned a publication saying that legal services overall contribution to history exposed the contradiction that the American government and the American society was really not willing to provide access to justice for the poor. It exposed the contradiction that the powerful forces, economic, social, and political, were not willing to pay with government money for the poor people to have the same access to justice and legal representation in cases, in administrative agency action, and in public policy, because they weren't willing to pay for someone to win their rights who were poor. So when we look at legal services 50 years later, they can't take criminal cases. They can't take boycott cases. They can't take abortion cases. Now they can't take immigration cases. And they can't take class action cases. They can't take school desegregation cases. And by the time you finish, you have a lawyer who's lost certainly 1 arm and 1 leg, and the other 2 limbs are limited in what legal services can do today. Nevertheless, legal services still brings significant action and provides significant representation in what they can do for the poor.
Do you have anything else you want to add about North Mississippi Rural Legal Services in particular? Any anecdotes or reflections? I actually wanted to ask one thing. Did you know Annie Lee Burt?
Sure, I know Annie Lee. She was the soul of legal services. She was a community organizer for legal services. She was an administrator for the staff.
Can you?
Yeah, Annie Lee Burt. She was the soul of legal services. She taught me life and culture in the South as a Northern Yank. Once through Annie Burt and another person who was always around and connected, L.C. Forgot L.C.'s last name. But within the year I was there, and before I became a vegetarian, L.C. invited me out to the country. L.C. was also the person who taught me how to maintain a weapon, to disassemble it, to oil it, to clean it, to reassemble it, and to shoot it, and know when to use it, and how to protect it from safety of misuse. And once L.C. and Ms. Annie Lee Burt took me out to the country where they captured a hog, and they shot it in the head, and they strung it up, and they cut it, and they put a bucket under it, and let it bleed. And later, they carved it up. And I came back the next day, I'll say that was a Thursday. They let it bleed overnight. And next day, they made what I call a homemade pit. It was kind of big, with just 2 cinder blocks on top of each other resting. And they got a welder to cut a big grate. So it was at least 3 feet by 3 feet square. And they started on Friday afternoon, early afternoon, 4 o'clock, filled with mainly wood, but some charcoal, beginning to roast that hog for barbecue. And they threw some hot dogs and hamburgers on the grill. And there was plenty of dark whiskey and plenty of beer. And we ate and we drank and we feasted till about midnight. I went home. And came back on Saturday, where the menses, as they say, had taken shifts and slowly barbecuing that meat. And by the time I got back at 4 o'clock on Saturday, that meat was ready to take off the grill. And of course, they put the homemade barbecue sauce on it. And they had plenty of white Wonder bread and potato salad and coleslaw and pickles and other parts. And that was my first feast on fresh barbecued meat at a picnic that nearly went on all the next night.
That's great. Could you reflect a little bit on the importance of the community organizers as part of rural legal services?
I think community organizers were equally as essential, or even more so, than the lawyers and the other administrative staff. When I went to this Reginald Hammersmith training in Pennsylvania in the summer of 1969 at Haverford College, one of my fellow mates was a man named Ken Cloak, who had a law degree, would go on to get a Juris Doctorate and become a leading professor at UCLA or USC. But I never will forget Cloak. Cloak said, as new Lawyers for the Poor, that was the original name of legal service, LSAP, Lawyers Serve the Poor. Legal Services for the Poor, LSP. He said, when we go to our assigned legal services program, we shouldn't put on any tie and jacket. We should dress like the community. After dropping off our books and anything else in our new office, we should leave and we should go out in the community. And we should stay in the community and not come back to that legal services program office until the people ask us to take a case. And we should stay in the community. You might be outside on the sidewalk, you might be outside. They had the community action programs, CAP, which had street offices and were created to work with the people, with community support organizations seeking public service benefits and organizing and other things. And we should work out of their offices, and we should sit with the people, and we should just listen. We shouldn't try and run anything. We should ask questions whenever they ask. And we shouldn't go back to our legal services until the people said we wanted to take action, and often after they exhausted all their means of direct support. Speaking of direct support, and just in one kind of international major news stories, over the last 10 days, the people of Puerto Rico have shut down the island, have stopped everything, have had demonstrations as high as 400,000 people throughout the islands, demanding that the corrupt and that the insulting governor, who had been caught with hacking in to the social network of the staff, and found that many staff, including heads of state agencies, had engaged in racist and vitriolic and sexist and other complete unprofessional language and thought and conduct. And it was a whole people's power movement that brought down the governor of the state of the Commonwealth of Puerto Rico. Well, that was what Cloak said. We should work with the people and support them in their direct action. If they're going to march, you help them get a permit. If they didn't get a permit, you defend them in criminal court for deliberate arrest, often in social disobedience. And that's what I think the community activists stood for in creating power in the people for the community. That's what also led the federal government to recognize the contradiction that they can't fund activists to bring civil disobedience against the state and the local and federal governments.
So what was it, do you know exactly how people like Ms. Burt, what their role looked like in just sort of an everyday setting?
In an everyday setting, they were like what my friend Ken Cloak said, in the community more than they were in the office. And when they were in the office, they were interviewing persons as the first intake, before they saw a lawyer. They would come to the lawyer and say, I've talked to this person, they're pointing out this kind of action, they want to know if they could do this, what do you think? So the first point was whether the community service person should continue work, or whether it moved to the next step of a lawyer-client interview with the person. Ms. Burke, though, for one particular instance in which I learned the value of the community activist, is that she would accumulate the knowledge that the local welfare office is disqualifying persons who don't have durational residency of a certain period of time before they are eligible. And she's accumulating all of this. So when she came to me and described the problem, and I conducted the research, I found that the durational residency requirement was unlawful. And then she would accumulate the facts like an investigator, and she would find the people who were willing to take action. And that was setting the stage to bring first an administrative action with the agency by a letter or by meeting, and if necessary, to escalate the agitation to litigation.
Great, thank you so much. So, are there any other people or events during your time at NMRLS that you would like to reflect upon?
Well, Skip Robinson, who became the leader of a movement for North Mississippi Legal Services, was what I would call one of the proteges I trained. Skip was in the Holly Springs office. He was the community organizer there. I also was like one of the lawyers, even though I was only 2 years ahead of him, who helped bring in Alvin Chambliss, my classmate, and who helped bring in Lou Myers, the firebrand of legal service, who indeed helped bring in William Joseph, who was the executive director before Ben for many years, and who was my client when he was at Mississippi Valley State University in 1969-70 as a junior or senior, and protesting and agitating against the president, Mr. J.H. White. And White arrested him for bringing in a speaker who was not approved by the university, and became a major speaker ban case that I represented them on. And I bailed the Valley State University students out of, again, Parchman Prison, and got all the charges dismissed against them, and later urged Wilhelm, a fast-talking Trinidadian, to go on to law school. And his photo in the class, which, by the way, Ole Miss is the only law school I know that has an electronic version of the normal law school class posted in framed pictures throughout the law school hallways. Theirs is all electronic on 2 machines. You go over there and see it. You punch in the year and it'll show you a group photo. You punch in the name and it'll bring up just like you're on your laptop computer. Each graduate by all the pertinent information. And Wilhelm is the only graduate I've seen in the parade of photos in which he is in an African cloth with open shoulders and draped on a diagonal across his chest in a traditional African garment. But in any event, that was part of the new wave of black and other lawyers. Another lead lawyer I helped bring in was David Littman, who went on to become an outstanding lawyer with legal services. And I think that was a part of the growth and the value of legal services. And many of them, of course, would go on to become lawyers in other agencies or in private practice in building this, what we call North Mississippi alum of lawyers in the state of Mississippi.
How do you think the existing legal community in Oxford and Mississippi in general even reacted to the presence of all of these young firebrand lawyers with legal services?
It made many lawyers at the time scratch their head. It was a process of evolution and acceptance. One of the catalysts that brought them together was the participation in the Black Lawyers Organization, known as the, what's the name of the state tree?
Magnolia.
The Magnolia Bar Association, which was had white and black lawyers in it, but quickly filled up with the new public interest lawyers in the state. That broke some of the barrier and created a pathway for understanding in the state of Mississippi. And for example, John Walker, who's one of the leading torts lawyers in Mississippi today, former president of the State Tort Lawyers Association, was a product of legal services. Fred Bank, to a large extent, was a product of a similar type of legal services where the Legal Defense Fund created their private law office and paid for the overhead for 2 or 3 years until they got on their feet and could exist on their own economically, and paid for Fred to take civil rights and poverty cases for a transition period. And now both Fred and Reuben are with one of the largest, most powerful law firms in the state of Mississippi, the Phelps law firm, Phelps Dunbar. That is history. That is a transition. That is, I guess, progress.
Well, I'm sensitive to time because you've given very generously, but I also want to give you an opportunity to reflect on some of your career, which has been long and very distinguished, after leaving there and after leaving Mississippi.
I've always said, particularly as a civil rights lawyer and often as a public speaker, that first of all, I did adopt some Southern vernacular. And I've always said that whoever and whatever I am today, it was all made in Mississippi, and particularly in Oxford when I first started. Here's perhaps my last funny story. Coming out of the 1960s movement, with all the social agitation here in Washington, D.C. and down through the South. And by the way, when I was in undergraduate school from 1962 to 1966, and when I was avoiding the draft by getting deferments, there was a major choice that particularly young men had to face, and that is whether they would quit school and forfeit their deferment and go south to join in the civil rights movement, or whether they would stay in school. And that was a big moral dilemma. And many quit, and they went into the South, and they faced the draft and faced problems of getting out of it or avoiding it or going in. I pledged that I would stay in school. And it carried me over from undergrad school, where I went to law school originally just to avoid the draft. And I pledged that if I finished the ultimate degree, I would go back to the South. And I also followed the old adage that for a young doctor to go to an undeveloped country such as Africa, they would see more in a short period of time than their counterparts who would go up the ladder, so to speak, here. And when I went to Mississippi, and when I brought my first federal action, and going to federal court requires more than going to state court, within 3 months in practice, my counterparts who had landed prestigious jobs at the firms would carry the senior lawyers' bags and go to court as a junior assistant for 2 years before they could ever think about even being number 2 in the seat of bringing a federal action. And so when I first arrived with this 60s culture, I wore Birkenstock sandals. I wore jeans, we called them dungarees then, pants. I wore a lighter colored dungaree shirt. And I wore a red or blue plaid bandana tied around my head and tied at the back. And once I went to a community meeting as a lawyer with North Mississippi Rural Legal Services in a church. And the people often made you stand in the pulpit, even though I didn't want to stand there, to talk to them about taking action. And I spoke one night in a church in Oxford, or out a little bit in LaFleur County, a black church with my so-called hippies look on. And as I was walking out and we decided to take action, an elderly black lady sitting in the pew as I was walking down to go out pulled me aside, and I bent over and she said, "Lawyer Brittain, we like to see our lawyers dressed as our preachers. You know what I mean?" I never went back to a church without having a suit and a tie and a jacket on. And if you look at all the photos back in the 30s and 40s and even the 50s, the lawyers, like Thurgood Marshall, were always dressed in a suit. Malcolm X and the Muslims were always dressed in a tie and a jacket. Martin Luther King always had a preacher's suit on, unless he was walking in a march in the hot street, and he would have appropriate comfort clothes on. And to this day, I teach my class always dressed. I give my speeches always dressed. I always go to any kind of community meeting looking like a preacher.
Well, thank you so much. Do you want to just very quickly go through the rest of your career? I know you were at Thurgood Marshall School of Law and
All right.
University of Connecticut.
I'll march it off.
Record, I want to have that captured if you don't mind.
All right. After 4 years in practice in legal services, I was recruited to come to Washington and to begin climbing up the ladder to head a major civil rights legal organization. I will come back to that in my trajectory in time. Or I was urged to come out of public interest practice and join the bar of Mississippi. And in hindsight, I think I should have done that, because I would have become a part of the tobacco litigation, and I would be a millionaire lawyer today, and I would become a major torts lawyer like Victor McTour and John Walker and others. And what was the lawyer, the famous lawyer from Oxford that won all those big damage actions and then got in trouble for bribing a judge?
Yes.
Dickie Struggs.
Yeah.
And Dickie was an old friend of mine. So I would have been the black Dickie Struggs of Mississippi and $1 million torts lawyer. But with that in mind, I had said that America is based upon the economic system of capitalism. So I'm now going to go out and try myself on. And like Scruggs, I did go out to San Francisco. I picked it because, one, I had a law classmate, a white Irishman from San Francisco, who invited me to come out and join him in what we call the salt and pepper practice. It became Brittain and Ryan. And I wanted to become a member of the $1 Million Round Table. That's any tort lawyer that achieves $1 million settlement or verdict in a torts case. And so I practiced law out in San Francisco for 4 years, from 1973 when I left Mississippi to 1977. Meanwhile, my mentor, as I mentioned, from Howard University in some of the Browns cases, Herbert Reed, had always nagged at my heels to go into law teaching and be like Thurgood Marshall and Charles Hamilton Houston, the father of the Brown versus Board of Education decision that de jure segregation was inherently a violation of the 14th Amendment Equal Protection Clause. And he finally convinced me, 8 years out of law school, to give up private practice and to go in law teaching. And it was coincidental that my home state law school selected me for the tenure track that I mentioned earlier, and I later became the first African-American tenure professor. And I was a professor and a civil rights lawyer in Connecticut for 22 years, from 1977 to 1999. And I was one of the lead lawyers in a major school desegregation case in state court, not in federal court, under the state constitution, not the federal constitution, to overcome some of the limitations that federal courts had placed on school desegregation cases. And after I finished at the University of Connecticut, I decided to accept an offer to become the dean of the Thurgood Marshall School of Law in Houston, Texas, at Texas Southern University. And I served as dean and later a senior professor at Texas Southern Law School from 1999 to 2005. And in 2005, the Lawyers Committee for Civil Rights Under Law, that organization that I joined in 1971, so from 71 to 91 would be 2001 would be 30 years, and in 2005 would be some 30, close to 5 years. I returned to the Lawyers Committee to become the chief counsel and senior deputy director here in Washington, D.C. And I led the Lawyers Committee with about 20 lawyers on staff and about 3 times that many lawyers from large law firms who provided co-counsel legal representation in major litigation from the trial court level up to the Supreme Court for 4 years until 2009. One of my signature cases is that I was one of the lead lawyers in a major landmark case against FEMA on behalf of evacuees in a case called McWaters versus FEMA, in which we kept people in temporary housing assistance from the storm in August, September 2005 into late in the summer of 2006. And we represented a class action of nearly 100,000 persons in temporary housing assistance. And I decided to step down and go back into legal education in 2009 to devote my remaining career to writing and to continuing with civil rights and teaching. And I chose the University of the District of Columbia here in Washington, D.C., the state's, quote unquote, only public law school among 6 major law schools in this greater Washington and Virginia area, including Howard University, a fellow HBCU school in Georgetown, and George Washington, and American University, and Catholic University, and George Mason University.
Well, I just really appreciate all this time you've you've spent with me today, and it's very inspiring, and I appreciate your work. So thank you for letting me have this opportunity.
I am always dedicated to the goals and to the activities of North Mississippi Rural Legal Services.